What happened? For judgment. Item number 17. What is this, sir? What is- Writ petition dismissed. Yes. What is this disturbance?
May I please, Your Lordship?
Yes, ma'am.
Lordship, I beg to mention here in item 14 and 15. I pray that this matter may come out on Thursday, that is 12.
We'll listen after a week,
Okay, Lordship.
not on Thursday. Yes, Mr. TB.
Sound is coming.
That's what, yes, some disturbance is there. Yes, on whose prayer? On the prayer of
Yangarwati CGC.
MS so Learned Council makes a mention on behalf of Mr. Yangarwati, the Learned CGC, and seeks adjournment of the case for a week. Prayer is allowed, listed after a week. We fix it and then on the date fix,
Lordship.
let us not give any date.
For motion, item number 17.
What is this disturbance? Oh. Call the technician. Call the technician. Yes, what is your case?
Lordship, the petitioner is praying for family pension.
Okay,
Lordship, the present petition is being filed by the legal guardian of the petitioner, Your Honor, represented by the legal guardian. Your Honor, I'm the disabled daughter of the deceased employee and pensioner as Nisa, Lordship. Lordship, my mother is availing family pension due to the demise of my father. Lordship, my name was not recorded in the PPO. After the death of my mother, I applied for family pension with all the necessary documents, Lordship. But the respondent authorities has not responded to my representation, Lordship. Lordship, the disability certificate is annexed in Annexure 3, page 13. In this certificate, the issuing authority has stated that I have 75% disability, Lordship. Lordship, even though my name was not recorded in the PPO, the AG office in its RTI reply dated 1/8/2022. In this reply, the AG office has stated that my mother has been availing family pension in page 42, Lordship. The RTI application is in page 41. The reply is in page 42 as well as page 42, Lordship. My apology, Lordship. Page 47. Page 45 to page 47. Reply letter is in page 46. Am I allowed to read, Lordship? Furnishing of information under RTI Act 2005 in respect of Smithy S. Nisa, wife of late N. Lorho. N. Lorho is my late father, Lordship. Inviting a reference to your RTI application dated 1/1/2022. I am to state that this office has issued authorized pension payment order in respect of Smithy S. Nisa, wife of late N. Lorho, holder of PPO number NL/SF/811. The next page, the name of my mother is listed in serial number 2, Lordship. Smithy S. Nisa, wife of late N. Lorho. Even though my name has not been recorded in the PPO, this shows that my parents, my mother is availing family pension on account of the demise of my late father, Lordship. My father was served as driver in NST and he demised, and out of that, family pension was sanctioned to my mother in
Yes.
the year 1982.
Madam Inauli, take steps to pay.
Your Lordship, at this stage, notice may be issued.
I
but Your
will issue
Lordship-
notice,
Your
but I
Lordship,
think,
here, I also want to make one submission, Your Lordship.
let us see.
Your Lordship, here is a case where the petition, the pensioner has expired. So in cases of where the pensioner expires, the DC has to make for making a new nominee, Your Lordship. And for that, DC will also have to be a necessary party, Your Lordship.
Okay, you submit your affidavit on the next date with all this. And we can order accordingly, okay? You give him a copy.
Yes, Your Lordship.
You see the last para. Just read.
Lordship, on 20 May 2022, I have submitted Form 3 of the pension room
To?
to the head office, to the NST, General Manager NST.
No. The thing is that, as per this, not, you read the office memorandum,
Therefore.
the last para.
Lordship,
Therefore, it is hereby. If there is to be any change in name, nominee,
Lordship,
an inquiry has to be conducted by the deputy commissioner. That is what this is.
Lordship,
Correct. Your case is that you have not been given the pension because you are not entered as the nominee in the PPO.
Lordship. Lordship, PPO was issued during the year 1980.
But your name is not there.
Lordship,
So, and you are now claiming the pension on the basis that you are the disabled daughter of the government employee.
Lordship,
So like, if that is the case, then an inquiry has to be conducted as per this office memorandum. That is
Lordship,
what it says.
Lordship. Lordship, during the time of issuing the PPO, there was no provisions for inclusion of the name of the dependents.
When did you file your this thing? Application?
The first representation was on 1/7/2019 only, Lordship.
2019, this is 2015.
Lordship.
Mr. Sanso, Learned Counsel for the petitioner. Stop. In the present petition, the petitioner is represented by the legal guardian. Stop. It is the case of the petitioner that she is the disabled daughter of Anne Lorho Mao, who died in the year 1982 while serving as a driver in the Nagaland State Transport. Stop. On the date of Anne Lorho Mao, the family pension was sanctioned to his wife. And the mother of the petitioner as Nisa. White PPO dated 14/6/1982. As Nisa, the mother of the petitioner expired in the year 2009. Thereafter, the authorities have stopped the payment of the pension, the payment of the pension. It is the case of the petitioner that she is the unmarried, unemployed, and has been taken care of by her legal guardian. It is also the case of the petitioner that after the death of her mother, the pension book, which was in the custody of the petitioner's mother, was lost and could not be traced. And because of which the FIR was lodged at Tadubi Police Station, Senapati District, Manipur, on 13/7/2022. It is also the case, It is also the case of the petitioner that the Office of the Principal Accountant General, Nagaland, in the RTI reply has acknowledged that the PPO number NL/SF/811 dated 14/6/82 was authorized in favor of the petitioner's mother. The petitioner, in order to avail the family pension, has submitted the representation dated 1/7/2019, comma, one 3/2022,
Twenty-five, 2023, Lord. Annexure 22.
and 25/7/2023. However, the same is not evoke any response. Stop. Being aggrieved, the petitioner is before this court. Issue notice to the respondents, returnable, After 4 weeks. Yes, ma'am, you have 4. 1, 2.
1 to 4, Your Lordship.
MS Inahuli, learned government advocate, accepts notice on behalf of respondent number 1 to 4, and MS so-and-so accepts notice on behalf of the respondent number 5.
Lordship, standing on behalf of my senior
Okay,
dishwasher.
okay. On behalf of respondent number 5. Therefore, no formal notice need be issued to the said respondents. Stop. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned counsel for the respondents within
2 days, Lordship.
a period of 3 days from today. Okay.
For motion, item number 18.
Wait, please, Lordship.
Yes.
By this writ petition, we're challenging the appointment of the private respondents 5 to 35, Lordship.
What is the impugn order?
Finding impugn order, page 53, Lordship. 53.
Different orders for each individual,
Yes, Lordship.
different orders for each individual
Yes,
respondent.
Lordship. And this were issued on the same day, Lordship. For all the private respondents on
On
the same day, Lordship.
1912.
19 December 2023, Lordship.
Yes, Mr. Nangami. There's something very wrong.
Lordship, yes, it appears that no advertisement has been issued, but.
No advertisement and in one day, how much?
35, Lordship.
35 appointments in 1 day.
Lordship,
Hari bhai, there's something wrong, huh?
notice may kindly be issued, Your Lordship.
When
1912.
12 December, have you come earlier? You could have stated this.
Yes.
Lordship, yes, Lordship.
Oh, this is issued on 12 December.
Yes, Lordship. We were filing RTI law. First place, we went to the extent of appeal, Lordship. Only after direction by the higher authority, Lordship, we were finished with this documents, Lordship.
So at this stage, we cannot state this.
Lordship, Lordship. Notice may be issued, Lordship.
If not, this is appointment of multitasking
Yes,
stuff.
Grade 4 employees, Lordship.
Where?
NIMSA, that
In
is
the Institute of
Medical Science and Research, Lordship.
new institute, new controversy. Very why? And you have made a regular appointment. Only thing is that they'll be on probation
Yes,
for 1 year.
yes.
Hari bhai. This is bad. Okay. That Mr. Mojamir. Learned counsel for the petitioner. Stop. The petitioners are all indigenous inhabitants of the state of Nagaland, hailing from Kohima district. Stop. They are all unemployed youths possessing requisite qualification and eligible to be recruited as multitasking staff within bracket grade 4 post. under the government of Nagaland. The petitioners are aggrieved by the series of orders, all dated 19/12/2023, individually appointing the private respondents to the post of multitasking staff at the Nagaland Institute of Medical Sciences and Research, within bracket NIMSR, Kohima. Issue notice to the respondents, returnable after 4 weeks. Mr. Nangami, the Leonard Senior Government Advocate, accepts notice on behalf of the respondent number
1, 2, and 3, my lord.
1, 2, and 3.
Yes, my lord.
Not for 4, no?
For your lordship, because it is a society.
1, 2, and 3. Therefore, no formal notice need be issued to the state respondents. Stop. The Leonard Counsel for the petitioner shall however serve the requisite copies of the writ petition to the Leonard Senior Government Advocate
During the course of the day, Lord.
in the course of the day. Insofar as respondent number 4 to
35, Lord.
35 are concerned, the Leonard Counsel for the petitioner shall take steps for service of notice upon the said respondents by registered post with AD within a period of
3 days, Lord.
3 days from today. It is made clear that the appointment of the respondent number 5 to
35, Lord.
35 shall be made subject to the outcome of the writ petition. Okay.
Deeply obliged, my lord.
For admission, item number 1.
Yes, Mr. Subramanian.
My blessed lordship, I filed the affidavit against the affidavit filed by the respondents, your lordship.
By state respondents?
Both as 1 to 5 and then private respondent number 6, your lordship.
Yes, Mr. TB. You are for?
And for respondent number 6.
Lordship, if I may be your lordship, in the affidavit filed by the respondents, they have enclosed a document stating that the principal director school education have written to the deputy commissioner seeking for administrative clarification and verification of channel and owner. And then they are waiting for the report. But then since last night, I received the report, your lordship. So at this stage, if direction may be given to the state respondents to obtain instruction from the department in the next listed date, the matter may be heard of, your lordship.
Yes, Mr. Kiang. I mean,
Even this morning, I spoke to the department representatives. According to them, they have not received the report. But anyway, since my learned friend has furnished, if I may be allowed to take step, lordship. Yes, lordship. Kindly grant me 3 weeks time to take step, lordship, to file for filing additional affidavit, lordship. Yes.
yes,
Lordship, I think this is this.
this is written by head DB.
Yes.
Yes, lordship.
Head DB to SD. Oh, Changtungya. Correct.
Lordship.
Any order given by this court to make this kind of inspection?
No, lordship.
No, lordship.
Then
Pardon for verification, Your Lordship, DC is the authority, Your Lordship, for conducting a verification of, for genuine land ownership. So on that basis, I think that the department, if they forwarded the letter to the Deputy Commissioner, Your Lordship, to ascertain the genuine land owner.
No, Mr. TP, whether there's any order or direction from this court to make this kind of inspection?
No, Your Lordship, but as per the policy of appointment on land, like appointment cannot be in perpetuity, it should be one time.
Uh-huh.
And in case if there's oral agreement, then claim is made on the basis of oral agreement, then Deputy Commissioner is to verify as to whether such
Yes.
agreement were there and whether any such.
But
appointment has been given.
all those conditions are subject to fulfillment of 3C.
Yes. 3C,
Yes,
Lordship.
3C.
So in the affidavit filed by the state respondent, and statement has been made that verification has been sought for from the Deputy Commissioner in the affidavit filed by the state respondent. Your Lordship.
Verification has been sought for.
From the Deputy Commissioner. But then
Oh.
this is not from Deputy Commissioner. But anyway, state maybe to file additional.
Yes, to receive necessary instructions, okay?
Lordship, Lordship. Lordship, 3 weeks, Lordship.
To clarify and to receive necessary instructions. Mr. Kiangami, the Leonard Senior Government Advocate. Shall receive the necessary clarification and the instructions on the letter dated 9/10/2023, which is written by Head DB, Customary Court, Changtungia, Nagaland, to the Subdivisional Officer, Changtungia, Nagaland, and is placed before this court by the learned counsel for the petitioner. Listed after 2 weeks.
Lordship, 3 weeks, Lordship.
Listed after 2 weeks. Okay.
Lordship, Lordship.
For admission, item number 2.
Yes, Lordship.
Yes.
Lordship, this is a fixed matter. However, Lordship, I have personal difficulties today. So, Lordship, we kindly accommodate to take up this matter next week, Lordship.
Mr. What the Jamia, the learned counsel for the petitioner, submits that he has some personal difficulties today and therefore seeks adjournment of the case after a week. Prayer is allowed, listed accordingly. Okay.
For admission, item number 3.
My future Lordship.
Yes.
Lordship, I'm mentioning on behalf of my senior Sandianga. Lordship, we are yet to file affidavit in reply to the affidavit in opposition filed by the respondents. So kindly grant us 3 weeks time, Your Lordship.
Your good name, Mr. So-and-so.
It's not like-
Learned counsel for the petitioner is allowed 2 weeks' time to file affidavit in reply. Listed accordingly.
Operation.
For admission, item number 4.
Yes, Your Lordship.
Yes.
Your Lordship, I'm praying on behalf of my colleague Ajungli, Your Lordship. Here, he's yet to receive instructions in this matter. So kindly grant 3 weeks' time, Your Lordship, to receive
The
instructions.
learned government advocate is allowed 3 weeks' time to receive the instructions and file affidavit in opposition. Okay.
My request.
For admission, item number 5.
May I please, Your Lordship?
Yes.
Lordship, I'm appearing on behalf of YP Gupta, Lordship, for all the respondent, Lordship. Lordship, I was informed that due to what condition he wouldn't able to appear, so I pray that this matter may be listed after 3 weeks.
Whether Mr. YP Gupta has been authorized by the railways?
Yes, Lordship. I was informed that he is appearing for all the private, all the respondents.
Your good name, Mr.
Mr. Kachishi, Lordship.
So and so. Learned Council submits that Mr. YP Gupta, the Learned Council will be appearing for the respondent number 1, 2, 3, 4, and 5. However, due to certain difficulties, he is unable to attend the court today, and therefore seeks adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly.
So, authorized, Lordship.
For orders, item number 6.
May it please your lordship.
Yes.
Your lordship, here, as per the last interim, your lordship,
Huh.
the petitioner have seek to file additional affidavit, your lordship, and to ascertain the address of the respondent number 3, your lordship. Lordship, however, the affidavit as well as the address have not been ascertained, your lordship. If
Pardon?
3 months, the address as well as the affidavit, your lordship, they are yet to be filed, your lordship. If 3 weeks time be
No.
given, your lordship.
The last order says additional AG submits that the affidavit in opposition will be filed only after the additional affidavit is filed by the petitioner.
Lordship.
So it is dependent, whether the state will file a affidavit in opposition or not will be dependent on your additional affidavit.
Yes, your lordship. Your lordship, that's why your lordship, if 2 weeks time be given, your lordship, to file the additional affidavit, your lordship. Lordship, may I please, your lordship, lordship, for respondent number 2 and 2, 3 and 2, 3, 6 and 7. We have filed our wakalan nama on behalf of Sentianga.
2, 6, 7, and 10.
2, 3, 6 and 7.
2, 2, 3, 6, and 7. Your wakalat nama is not there.
Lordship, we have filed today morning only.
Hmm. Mr. Your good name? Your good name?
Noklai M.
Mr. So and so. Learned Council submits that Mr. Senti Younger and Associates have filed their affidavit, have filed their wakalat, have filed their power to represent the respondent number 2, 3, 6, and 7 only this morning. The same is, however, not available on record. Registry to trace the same and place it on record. Mr. M. Solo,
Yes, your lordship, on behalf of Kamer Alim, your lordship.
Learned Council makes a mention on behalf of Mr. A. Kamai, the Learned Council for the petitioner, and seeks adjournment of the case for 2 weeks to file additional affidavit. Prayer is allowed, listed record.
For orders, item number 7.
Yes, Mr. MT.
Lordship, this is pertaining to that jurisdiction of the Dubai court. So it's a covered case and Dubai court is not a appellate court. So your Lordship, state respondent unable to file a affidavit in opposition because it's a covered case.
At least file a small affidavit, just
Lordship,
1-2 line affidavit, that's saying that at least we will have to take the
This
stand of the
honorable
state.
court has also given a very comprehensive judgment covering this matter.
Are you ready? The government is giving you the liberty to argue. You are on behalf of petitioner. Oh. What is the judgment, Mr. MT?
I don't remember, but
Produce it.
yeah, I'll produce. It's
This
covered
court is
case.
also, I think, aware of many judgments, but I don't have even a single copy with me.
Next step, I'll produce.
You
that
produce.
judgment.
The petitioner has filed the affidavit dated 13/8/2024, stating service of notice by dusty process upon the respondent number 5. Stop. Service on respondent number 5 is therefore deemed served. Mr. M. T. Song, the learned additional AG Nagaland, shall on the next date place a copy of the order wherein it has been decided that the Dubai Court in Nagaland has no appellate jurisdiction, to decide matters from decision of the
Village court.
decision of the village court. Okay. Listed after 2 weeks.
2 weeks.
Okay.
Worship, there's an interim order.
The interim order passed earlier shall continue till the next returnable date. Okay.
For orders, item number 2. Item number 8.
Please, Your Lordship,
Yes.
I've taken steps against all the respondents, and I'm not certain whether the steps have been completed or not.
Return service report is awaited. When
Yes.
have you taken?
Maybe 20 or 21st of August, Your Lordship.
Shall we wait
We
for
can
2
wait for
weeks?
some time, Your Lordship.
Office note dated 5/9/2024 states that return service report in respect of respondent number 1 to 7 is awaited. Listed after 2 weeks.
Your Lordship, there is an interim that may be continued.
The interim order passed earlier shall continue till the next returnable. date.
Much obliged.
For orders, item number 9.
Lordship, as per the last court order dated 12/8/2024, we have taken steps to the respond through register ID to the respondent 1, 2, 3, and 4, Your Lordship.
Office note dated 5/9/24 states that service notice issued upon respondent number 1 to 5, 1 to 4 is awaited, listed after 2 weeks.
Lordship, there is an interim.
The interim order passed earlier shall continue till the next returnable date.
Operation. For orders, item number 10.
Your Lordship here.
Service report in respect of respondent number 4 awaited. Mr. Limawabo. You are appearing, Mr. S. Tamjan. Okay, very good.
Lordship, by order dated 23/8/2024.
23/8.
Lordship,
Ah.
Lordship, the notice on my interim brief was issued when the government it was directed to obtain the instruction. In this case.
What is your case?
Lordship, this is a case, a selection was conducted.
And the selection committee recommended my case for appointment. In spite of the said selection, the private respondent was appointed. That is the issue.
You were selected consequent to a proper advertisement.
No, there was no advertisement, but as per the direction from the
What is the post?
MGs, multitasking staff.
Oh, MTS. Okay, but since Mr. S. Temjen is appearing only today, let us at least give him an opportunity to study the case.
Your Lordship, an endeavor will be made to dispose of the case at the early stage.
How much time you will require? Yes, madam, how much time you will
Here,
require?
I'm praying on behalf of VG Mos, 3 weeks, Your Lordship, as he's yet to receive instructions, Your Lordship.
Lordship, Lordship, I would like to bring to the notice.
You are respondent number?
Respondent number 4.
Yes.
Lordship, I would like to bring to the notice of this honorable court.
Yes, please.
That prior to this petition, another writ petition was filed, and then challenging the same impugned order. In that writ petition, the court has given an order that the appointment of the private respondent will be subject to the outcome of the writ petition.
Private respondent means the
Yes.
private respondent therein will be?
That is me. In that writ petition, I am
Oh.
the respondent number 6.
Oh, so your appointment will be subject to the outcome of
Yes,
the writ petition?
in that writ petition, earlier petition,
Okay.
prior to this petition.
Okay.
And then in this instant writ petition.
So what happened to that? What happened to that?
So
Still pending, Lordship.
after that, Lordship, this is the.
No, whether that the prior writ petition has been disposed?
No, Lordship, it's
Still pending?
Yes. Yet to be, Lordship.
Huh?
Your
Why
Lordship,
again this, why again, if the subject matter is same?
No, Lordship, it's like this. Lordship, three candidates, they appeared in the interview. And the other writ petition was filed by another candidate, not me.
Oh, in that.
Lordship,
So why don't we club,
Lordship, facts is little different. Lordship.
facts different, okay. Okay,
Lordship, but concerning the same post, if the meter can be clapped.
but same post.
Same post.
So there are now many candidates.
Two candidates.
Two candidates. The two writ petitioner challenging my appointment, Lordship.
Oh,
Lordship.
you were inviting problem, huh? For all these people. What is your case?
Lordship,
Why actually you are favored?
Lordship, I have some certain materials, but if I'm given them
Okay,
opportunity,
okay.
I'll.
Yes. Mr. S. Temjen. Appears on behalf of the respondent number 4. Both the government advocate as well as Mr. S. Temjen, the learned counsel for the respondent number 4, are allowed 3 weeks' time to file their respective affidavit. Listed according.
The other writ petition also defined this.
Okay.
Petition number 165 of.
Okay. Take the present writ petition along with WPC
165 of 2024.
165
Of the 2024.
of 2023. 24 of 2024. Okay.
For orders, item number 11.
Lordship, the matter pertains to subsequent posting of the Director of Higher Education, Lordship. And the date was fixed for hearing of interim. However, Lordship, I have an instruction by my client that the matter has been amicably settled outside the court on the assurance given by the minister. So I have instruction to withdraw the case, Lordship. May we be allowed to
Yes,
place-
very good, very good. This was regarding your retirement.
No, Lordship, it's.
This is a
pertaining to-
different case.
Yes, the director was posted as OSD, Lordship.
Oh, okay. Yes, ma'am, have you seen this?
Lordship, I am appearing for 2, 3, and 4.
Okay, this letter will do.
Lordship.
Huh? Mr. TV, you are for
Two,
all the respondents.
2, 3, and 4 for a department, concerned department.
Mr. Mojamir. The learned counsel. By placing a copy of the note. What should we call this? Note?
Note, Your Lordship.
Copy of the note dated nil.
Lordship. There's no date, Lordship.
Addressed to the Commissioner and Secretary, within bracket, HNTE, Government of Nagaland. Submits that. In terms of the said note, he has instructions to withdraw the writ petition. The writ petition is accordingly closed as withdrawn. The note dated nil issued by the Honorable Minister,
Tourism and higher.
Tourism
education.
and Higher Education, Nagaland, Kohima, shall be placed on record. Okay.
Also, I may be given liberty, Lordship, if circumstances arises, Lordship.
What was the last line, man? You are not fully relying.
What is this?
Just before that, just before that.
With liberty.
Then as withdrawn, with liberty to file afresh. Okay. So you are a little hesitant.
All right.
No, this
No,
notice
it
in
will
favor.
be.
Okay.
For hearing, item number 12.
Lordship, on the last occasion, my learned friend Vito was supposed to bring some, you have given, Lordship has given some homework to him.
Where is Mr. Vito?
He was here little earlier. But I was informed you could not get your homework done.
Have you called, sent somebody to call Mr. Vito? Yes, Madam Inaholi, where is Vito?
He's on his leg, it appears.
He knows that a part that matter is listed.
Yes, motion letter. It can be listed after.
We will impose fine for wasting the time of the court. Part heard, part heard, part heard.
Yes, Your Worship, it can taken up after some time, if Your Lordship may agree, Your Lordship.
Okay, let us just see.
Lordship, there is
Anyhow,
in another matter just after this, and yes.
Hello, I was on like in court number 3.
yes,
And motion matter was taken up, but however, since this matter has come up, Lordship, on the last occasion, this honorable court has directed the state respondent to produce the judgment and order that was reflected, that were taking reference in the OM dated 2017, Lordship, with regard to the accounting of ad hoc work charge for retirement purpose, Lordship. However, Lordship, on the last, yesterday, I went to the PNR department to get that judgment and order, which I could not extract from the registry, Lordship. Thereafter, Lordship, I'm told that officer who is in charge, who is on leave till date, and we could not trace the other course order, Lordship, 2 course order, Lordship.
So what is to be done?
So Lordship, if Lordship please, Lordship convening then on the next week, Lordship, so that I'll make an endeavor to.
Not an endeavor.
No.
Enough is enough. You have been given enough time, and this matter has been listed part heard.
Lordship.
I think henceforth we will impose course for wasting the time of the court.
Or else we can take up the matter, Lordship, if Lordship.
If you have the judgment, you let us see whether.
Lordship.
Yes, Mr. Apok.
Yes, Your Lordship.
Well, just to brush up, what is your case? Just to brush up.
In a simple manner, Lordship,
Yes.
I am claiming that I was prematurely retired from service. Because, Lordship, I was initially appointed on contract in the year 1988. And thereafter, there was a 3-month gap in 1990, 3-month period.
3 months gap.
Yes.
Ah.
And only in the year 2001, I was regularized with effect from 9/12/1998.
1998.
The letter of approval was issued on
When were you first appointed?
88, Lordship. 1988.
1988. And the gap of 3 months was between
In the year 1990. Because, Lordship,
1990 for which months?
Lordship, August, September, October, no, July, August, and September, Lordship. Because, Lordship,
Just wait. August, September. This was the gap.
yes, Lordship. The last extension order of 3 months was granted on March 1990, 30th March. And
Last extension order,
yes,
March
1990.
1990.
Yes,
This was the last extension order given to you.
yes. In that extension order, Lordship,
Okay,
there was a rider attached to it.
okay.
The rider states that he may not apply for further extension. And true to the words.
Last
I-
extension order, March 1990. So your last extension order was up to June.
June, Your Worship. 3 months. 3 months extension order was granted on 30th March 1990 up to the last of June 1990. And
With the rider that
he may not apply for further extension. And consequently, Lordship, I was not allowed to join, report for duty. I was not given any.
Okay, so
salary.
till this time,
Yes.
your case is that 1988 you were appointed. Correct?
Initially on contract.
You were appointed 1988.
8.
Okay,
80.
and thereafter, by the order dated March 1990, the last extension was given up to June 1990 with a rider that you need not apply for
Apply
further
for further
extension.
extension.
And there is a gap of 3 months in the year 1990, that is for the month of July, August, and September. Yes.
Thereafter, Lordship, in the month of October, I was instructed, verbally instructed by my controlling officer. to resume-
October 1990.
Yes, Lord,
Ah,
to resume my duties. There is, Lordship,
Yes, yes.
unfortunately, there is no specific order. Since I was instructed by my controlling officer, I resumed my duties as.
You
custodian.
joined, accordingly, you joined
Yes.
October
So,
1990.
Yes, from 1990 October, I started again. And then from the month of October, I started drawing my correct allowances.
Yes.
Then, Lordship, in the meantime, during 99, a proposal was sent to the Home Department.
99.
Yes, a proposal for regularization.
So
of
from
assets.
October 90, you continued.
I continued, Lordship.
And October, 1999.
Yes, Lord.
What happens?
Proposal was initiated by the BHQ, whereby my services were proposed for regularization. Lordship, on the basis of that letter of on the basis of that proposal, the Home Department issued an order in 2001, whereby my service was regularized with effect from 9/12.
2001.
Yes.
Order issued, huh?
Yes, Lordship. That is 26/5/2001. That is
Your order was issued regularizing your service
This is the letter of approval, Lordship.
with effect from
9/12/1998. That is specifically mentioned.
12/10.
No,
19?
9/12.
9/12.
1998.
1998.
Lordship, that is annexure 9 of the petition. Lordship, when this letter of approval was sent to the BHQ, the small mischief took place, Lordship.
What is that mischief?
The mischief was that on the entry in the service book, initially they written the date as conveyed by the Home Department, but they struck it off and they wrote another line.
Let us see that. Let us see
Yes.
that.
Yes, yes. Lordship will turn to page 40.
40.
Yes, Lordship. This is the entry.
40. Yes, and where is the mischief?
This is the extract of the contract service in respect of Constable Trevor Lakshman Sonar, attached to bulletproof car of His Excellency, the Governor of Nagaland, is hereby regularized with immediate effect. This was struck off, Lordship. And from the date of joining,
This is with
the Governor is here, Governor of Nagaland is hereby regularized with effect, with immediate effect. It was originally written.
this words which has been struck off.
Yes.
This
And
is
these are-
with
these are
immediate effect.
With immediate effect has been,
No, this is with immediate effect.
yes, Lordship.
So this with immediate effect has been struck off.
Yes, Lordship. And from the date of joining, it has been written. Lordship,
Just wait. And
Lordship,
it is,
wait.
instead of that, it is from the date of joining.
yes.
By mentioning the date of joining, they are taking me back to 1988. Lordship, may I just take your lordship to one next year, that is
Yes,
page
yes, yes.
Lordship,
But
this has a reference to the letter of approval contained in page 38, lordship, annexure 9. Previous to
38,
38.
the type copy is 39.
Yes, lordship. May I just read this one?
Yes, please.
Lordship, this is from the Home Department, Police Establishment Branch. Lordship, to the Director General of Police, regularization such and such. Sir, I am directed to refer to your letter number BHQ such and which is the letter I mentioned, lordship, earlier, 99, on the subject cited above, and to convey the approval of the government for regularization of the service of Constable Trevor Lakshman Sunar attached to bulletproof car of His Excellency, the Governor of Nagaland, with immediate effect 9/12/98, lordship. This is the letter of approval. And this has the approval of the Chief Secretary, Nagaland and BNR OM Cell, Vitir, dated 25/7/2000, lordship. This is from the Secretary to the government.
So basically, your case is that your service has to be counted with effect from 9/12/1988 instead of
98.
instead of 88.
Yes, instead of 88, it has to be counted from 98. Because that is the day when I was
And,
substantially appointed.
In order to deny you that, the mischief was committed at page 840
Yes, lord.
with immediate effect from the date of joining.
That makes a great difference, lordship. Oh, lordship, basically I've completed the other day and my friend was started to locate those judgments that has been referred in the office memorandum of 31st August 2017.
But Mr. Apok,
Yes, Lord.
if your service between 1998 and 88,
Yes, Lord.
there's a gap of 10 years.
I'm not getting 10 years, Lordship. I'm getting 3-4 years because I will be sovereignating, Lordship, not on the
By
land of
age.
service. By age, Lordship. I'm not getting the benefit of 10 years, Lordship. It's not the case that it's not that.
Yes, please.
Lordship, otherwise, should I continue or let my
Yes.
because I've virtually. So, Lordship, my whole claim is that since by the approval letter dated 2001, I was regularized in service with effect from 9/12/98. My date of that is the date of my regular appointment, regularization, where when I was substantially appointed to pensionable post. Therefore, my retirement and subordination should be from that date only.
Where have you stated in your petition?
Okay. 27, I've Para 27, Lordship,
Para 27. Please read.
that it is also submitted that the authority had erred both in law and in fact by mechanically applying the Nagaland Retirement from Public Employment Second Amendment Act 2009 without proper scrutiny as to the break in service that had taken place during 90 for more than 3 months, when even a day break in service will amount to non-continuous service. Even otherwise, the fact that the petitioner was regularized with effect from 9/12/98 only, which is the date of his substantive appointment, the petitioner could not have been released from service without completing either of the two conditions specified under the Nagaland Retirement from Public Service, that is 35 years length of service or 60 years of age, whichever is earlier. In the present case, neither of the conditions mentioned above have been fulfilled. And as much as counting from 98, the petitioner will complete 35 years length of service only in the year 2023, while the petitioner would attain the age of 2033, Lordship, while the petitioner would attain the age of sovereignty in the year 2028, since his date of birth as recorded in the service book is 1968. Therefore, the present is a case where the respondent authority had manifestly committed an error by wrong calculation and thereby causing immense loss to the petitioner as he had been prematurely and forcibly sent on retirement from service.
Yes, last time we see. Last time you had actually finished two books, no? Retirement from public. No, not that text. Retirement from Public Employment Act 1991
Volume
and
3.
Public Employment Second Amendment Act 2009. I think that is the one.
Yes.
You see. This is Second Amendment Act 2009, and let us see. Was that 1991? I told you to keep the books there. Yeah. 1991. Let us see the 1991. Whether it is here. It is here.
3.
It is here.
3. Volume 3.
It is here. Do one thing. It is not necessary for me to carry this bulky book. Yes. This is just 3 pages, 4 pages. This is just 2 pages. Just 2 pages. Make photocopy. Tell them to send it. Photocopy of this. I will just fold it. Okay. This one. Okay. And this is. This will be starting from this. To this one. Just 4 pages. Okay. 1, 2, 3, 4. Okay. Yes. Yes, Mr. Apuk.
Yes. Lordship, the government, the state respondent has come up with, by filing affidavit, you have stated that you have annexed one attendance salary statement for the year 1990 for the month of September.
Yes, please.
Lordship will find that at page 8 of the affidavit counter of affidavit in opposition.
Affidavit in
Opposition of the
filed by
state.
the government.
Yes, Lordship.
Affidavit 1, 2, 3.
Yes, Lordship.
Affidavit in opposition
Yes.
1, 2, 3.
Yes, Lordship.
Which page?
8.
Page 8.
Yes. This is allegedly the salary statement for the month of September 1990. And the allegation
This
is
is
that
salary statement.
that is
Just wait, Mr. Apok, this not clear.
yes, type copy is in the next page, Lord.
Type copy.
Yes, Lord.
Okay, 8, 9.
Lordship, let this in the main body of the affidavit, it is stated as a B slip. not a
Stated as
salary.
a
B slip as at page 3, Lordship. We'll copy to page 3.
sep-
Page 3. Page 3 of the affidavit, where do you have annexed the? This is the body where. Lordship was found, page 3 of the, paragraph 4.
page 3.
Yes, paragraph 4 of the affidavit.
The
This is
Yes,
where
it
they have
is.
annexed the stated as a
page,
B
page
slip.
3.
Yes,
Para
page 3, paragraph 4, but at the bottom, Lordship. Where,
page 3. Oh, page 3, para 4.
yes, at the bottom, Lordship. Paragraph 4.
However, the records pertaining to the man is not traceable. However, the petitioner, the action of the therefore misleading.
This is.
Where is that pay slip?
It's the copy, a copy of the B slip is annexed herewith and marked as annexure A. Yes.
Pay slip.
Yes. It's, stated
Okay,
to
so
be the-
this is referred to as the pay slip.
Yes, Lordship.
Salary statement.
My,
Just and
my
five
name is.
587.
Yes, Lordship. My name is.
Laxman
Sona.
Laxman Sunar.
My name appears
587.
587. And
And
because
this is to show that the
I have, my name is reflected in the B slip
No.
and I have thrown the salary for the month of September.
well, how do I actually decipher that?
Lordship, I'm just saying, my condition.
No,
in the
no,
re-
no, no. Let me just clarify from this Lakshman Sunar. From this government is saying that you have been paid salary up to
No, they're not saying, for at least for the month of September 1990, they say that
September.
I've been paid the
So
salary. Do you have no record for July, August? That's the statement. And my,
no, from here, where do you show that actually the salary of September has been drawn by the petitioner?
Lordship, nowhere it's shown. They've shown the statement, but I have not put my signature in it. Nothing is there.
Oh, on top, they're saying it's September 1990.
Yes, they've written it. That's what I've said the other day also. Lordship. This is a very recent handwriting. The other copies are not legible, but 30th September 90 is very legible and very clear. That the additional superintendent of police at the bottom have not put any date, Lordship. We can ascertain whether it is actually is for the month of September 1990. But even assuming, at least for, even if I'm not admitting, Lordship, but in my reply, I
Just
have
wait,
stated that.
just wait.
So, Lordship, the alleged B slip for the month of September 1990 is doubtful to my mind.
Have you filed your reply?
Lordship,
Let's see your reply. What have you stated in your reply? Affidavit in reply, okay.
Para two,
Yes, wait. Yes, wait.
should I read the whole thing?
Yes, wait,
Lordship,
yes, wait.
That is,
No, regarding this salary slip,
yes, it contains everything, Lordship.
in which para?
Two.
Para
Again,
2.
That as regards the amendments made in para
Just
four.
wait, just wait. Yes.
Lordship, that as regards to the statements, amendments made in bearer four of the affidavit in opposition, the deponent, while reiterating the statements made in paragraph 3, 4, and 5 of the writ petition, it is stated that the initial appointment of the year in the year 1988 was on contract basis, and the petitioner continued to be in that capacity till 30/6/1990 on the basis of various extension orders issued from time to time by the competent authority. It is reiterated here that the last extension order was issued on 30/3/1990, whereby the contract service of the petitioner was extended for a period of 3 months, with effect from 1/4/1990 to 30/6/1990, wherein a stipulation was made to the effect that he may not apply for further extension. It is categorically stated that no further order of extension was issued thereafter, and the petitioner remained unemployed and no contract salaries were paid for about 3 months. As regards the allegation that the salary for the month of September 90 was paid to the petitioner, the same is denied as false. And as much as the petitioner did not receive any salary for the month of September 90, in the alleged salary statements annexed to the affidavit in opposition, purportedly for the month of September 90, does not contain the signature of the deponent, nor does it contain the official seal of any or signature any officials of the department. Therefore, the purported salary statement of 90 is a doubtful document which cannot be relied upon. Even assuming that the said document is a genuine document, the fact remains that the petitioner remained unemployed for the months of July and August, which is a clear indication that there was a break or gap in service, and consequently, it is immaterial whether the petitioner remained unemployed for a period of 3 months or 2 months. What is material is that there was a break or gap in service, and the petitioner's contract service till regularization on 9/12/98. The allegation that the petitioner had approached this honorable court without clean hands and heart is categorically denied. So as far as the salary slip, the B slip is concerned, that's it. But in their affidavit again, they have annexed the office memorandum dated 31 August 2017, which is the latest office memorandum in so far as.
In the affidavit in opposition filed by the state.
Yes, Lordship, page 21. This is the latest memorandum on counting of contract or worker substitute period for retirement purpose.
Page
21, Lordship. And this.
Yes, yes. Page 21.
Yes. Starting from 2012, the entire memorandum issued by government from time to time has been superseded by this memorandum. Lordship. And Lordship, with this memorandum, in fact, helps in my case. Supports my case, sir. Because at para 6 of the memorandum,
Yes.
and Lordship, while replying to this, your Lordship had given the homework to my learned friend.
Yes, yes, which is that relevant paragraph in this OM?
Lordship, Lordship has directed the state government to refer to para 3 and para 5.
Can we read from para 1, 2? Leaving aside the judgment, 1, 2.
1, 2 in 6. 1, 2, 4, and 6.
Yes, let us see, just read.
Para 1.
Yes.
Nagaland, Lordship, the counting of contract ad hoc work church substitute period for retirement purpose. The Nagaland Retirement from Public Employment Act 1991 defines public employment as appointment to any pensionable state public service or post connected with the affairs of the state of Nagaland in the Nagaland Legislative Assembly, and includes any appointment under the Government of India or other state governments, central or state public sector undertaking, and local authority held by persons prior to their absorption under the public service of the state of Nagaland in the Nagaland Legislative Assembly, which counts for the purpose of pension. 2. And whereas clarifications have been sought by departments from time to time whether the services rendered in ad hoc contract work charge substitute capacity prior to regular appointment made through the Nagaland Public Service Commission or Departmental Selection Board or any other prescribed procedure shall count as public employment for the purpose of calculation of length of it should be length of service under the above act. Then 4, when whereas the department had issued office memorandum of even number dated 1/8/2012 regulating counting of past services as public employment for the purpose of pension under the Nagaland Retirement from Public Employment, Second Amendment Act 2009. 6. Now, therefore, it has been decided that the period of service rendered on ad hoc contract work charge substitute basis, which is followed by regularization or regular appointment without break or gap in service, except resignation, shall be treated as public. That one, apparently one word is missing, Lord. Treated as public employment should be to my mind. Under the Nagaland Retirement from Public Employment, Second Amendment Act 2009. This supersedes all office memoranda on the subject, including the office memorandum dated 29 March 2017. So in terms of this,
Yes. Cool. Let us have a 3 minutes break.
5 minutes. 5.
Okay, okay. Yes, please.
Lordship, therefore, my case is squarely covered by this Office Memorandum dated 31st August 2017, particularly at para 6.
Yes.
Just go through, read again para 6. Now, therefore, it has been decided that the period of service rendered on ad hoc / contract work charged substitute basis, which is followed by regularization or regular appointment without any break or any gap in service except by resignation, shall be treated as public employment under the Nagaland Retirement from Public Employment Second Amendment Act 2009. Lordship, I've already pointed out there was 3 months break in service between 19 July to September in my case. And therefore, this memorandum in fact helps in my case. Lordship, the other day I have referred to one judgment.
Have you,
Yes,
have you given that?
I furnish it. Otherwise, I have extra copy.
Just. On the last date, have you given me the copy,
Yes, Lordship, I did, but I can give you another one.
the photocopy?
Yes, photocopy.
Let us see. Wait, it's not here.
This is a life law, Lordship.
That photocopy. This Director General Dordashan.
Yes, Lordship.
Uh-huh.
Lordship, in the head note, services rendered as casual, contractual cannot be said to be services rendered on substantive appointment. Can't be counted towards qualifying services for pensioner benefits. The High Court has materially erred in observing that the contractual service would be qualified as service in a temporary capacity.
Hmm.
Lordship, Para 7, may I just read it? The relevant portion is Para 7, starting the last line, Lordship. Therefore, starting from therefore, the services rendered on a substantive post or services rendered as officiating or temporary service shall be treated as qualifying service. Services, this is important, rendered as casual, contractual, cannot be said to be officiating or temporary service. Even the services rendered as temporary service can be considered for as qualifying services, provided that the officiating or temporary services is followed without interruptions by substantive appointment in the same or another post. Service rendered on casual, contractual cannot be said to be service rendered on a substantive.
Read
appointment.
once more, even the services rendered as temporary service can be considered as
Lordship,
provided that, there's a writer.
Yes, provided that the officiating or Lordship, in this case, there has been a distinction has been made. Lordship will go back to Para 7. Beginning, it further provides fourth line.
Which Para 7?
Yes, fourth line. It further provides that such officiating or temporary service is followed without interruption
Hmm.
by substantive appointment in the same or another service or post. Lordship, the two distinction has been made, Lordship. In either on officiating or temporary as one category and casual and contract as another category, Lordship, in this case.
Casual, where is that the
Coming
section?
to the next page, Lordship. Services rendered. Second line.
Okay.
So the two distinction has been made between the officiating and temporary as one category and casual and contract as the other category. So therefore, Lordship, service rendered as casual and contractual cannot be said. Even otherwise, the service qualifying service provided the officiating or temporary service is followed by without interruption by substantive appointment in the same.
But this is a case where actually like this judgment was given while deciding a case on the central service pension rules.
Lordship, the state government has adopted the pension rules. The state of Nagaland, we follow the same rule, Lordship. But the material fact is that whether contractual and casual services, whether the services can be counted. And it has been said that it cannot be counted. either way, Your Lordship. And Lordship,
So you mean to say that this judgment will have precedence
yes,
over the Nagaland Retirement from Employment Act?
Lordship, yes.
Then in that case, you are not entitled to the benefit of Nagaland Retirement from Employment Act.
Lordship, they,
Either dispute that way.
no, Lordship. Even otherwise, the 1972 rule is applied.
You are saying that as per the Nagaland Retirement Act, you will have to go on retirement only in the year 2033.
That is,
Whereas
if I,
by
no,
referring to
Lordship,
this judgment,
I've
you are
to-
saying that the Nagaland Retirement Act is this judgment will supersede Nagaland
I've
Retirement
said-
from Employment Act. You are
two,
appropriating and
two ways,
appropriating.
Lordship. One is 2033, that is, if we count 35 years of service. But I'm saying in 2028, I complete 60 years.
That is as per the Nagaland Retirement from Employment Act.
That's it.
That is.
Yes.
That is why you cannot make such a submission that this judgment overrides the Retirement Act.
Lordship, the law.
Then in that case, you cannot have the benefit of Retirement Act also. If you say that this judgment overrides the Retirement Act, then you cannot actually claim any benefit under the Retirement Act also. That is what this court is saying.
No, Lordship, that is to my humble understanding that it may not be the correct interpretation. Lordship, on this ground, your Lordship has directed my friend to refer to para 5. Lordship, para 5 is the judgment in the division bench where your Lordship was part of the council. This is read appeal 5 of 2017. This is a writ appeal number 5 of 2027. Lordship,
Okay, since the government is relying on that, let the government satisfy this court on that.
but
Then
I
you
will-
can reply always. You can
Alright.
always reply. Yes, so yes, your further submission?
Lordship, I will wait for.
Yes, Mr. Jimomi,
May I please,
yes,
may I please the Lordship?
just wait. Yes, please, yes, please.
Lordship, by, on 27/3/2024, we have filed, state has filed a counter. Respondent number 1, 2, 3. Lordship, we have categorically stated the paragraph 4, 6,
Just-
and 8
just-
of our affidavit.
Just wait. Affidavit in opposition on behalf of respondent 1, 2, 3. 1, 2, 3.
Lordship.
Yes, please.
We have categorically stated in the paragraph 4, 6, and 8, Lordship.
Just wait.
Here,
Para, you are referring to para 6.
4, 6, and 8.
Para 4,
6, and 8.
6. Yes, what is your stand?
Lordship, our stand is that Lordship. Lordship, but there is no denying fact. Even the petitioner, they are admitting to the fact that they were appointed in the year 1988,
Ah,
1/4/1988.
Correct.
Now, what the petitioner is praying before this honorable court saying that there is a gap of 3 months. That is 1990, July, August, and September, Lordship. There was a gap of 3 months where salary was not paid to him. But from the annex that we have annexed in our affidavit stating that the salary was paid to the petitioner for the month of September 1990.
Where have you stated that, Mr.
We have
Imam?
stated in paragraph 4 of
4.
our affidavit, Lordship. If I may allow,
Yes, please.
paragraph 4, page number 2, Lordship. If I may allow to read.
Yes, please.
4, paragraph 4. That with regard to the statements where in paragraph 3, 4, and 5 of the writ petition, not correct and denied in total. The petitioner was initially appointed as constable driver.
No, you are reading.
I'm
you are-
reading paragraph 4. Page number 2, Lordship, affidavit in opposition.
I
of
think,
Commissioner.
I hope that your contents and this is not different. You read from the beginning. Let us see paragraph 4.
Paragraph 4, that with regard to the statement made in paragraph 3, 4, and 5.
No, here this only says paragraph 4 and 5. This affidavit signed by Tamjin Sulai, Jamir IPS.
Lordship.
Then,
Of the writ petition.
you are reading para 3 or 4?
Para 4, Lordship. Para 4. Para 4 of the writ petition.
Read para 4.
Of the writ petition not correct and denied in toto, the petitioner was initially appointed as constable driver under the establishment of DF Kohima on contract basis and was enlisted appointed on 1/4.
No, Mr. Veto, I think there is something wrong with your affidavit. There's something wrong. You read this?
Lord.
Yes, kindly give him this. Kindly give him this. You read this. You compare your para 4 and this para 4. Is this the affidavit you are referring? Just see. Just see. Is that the affidavit?
Lordship.
Then you make a comparison between your copy and the court's copy. You just see that para 4.
Lordship. Lordship, in that way, so that I make a necessary correction.
No, whether you're, I think you have a different pleading.
Lordship.
As compared to the copy your lordship has, yes, there are some material, because in para 3, you have replied for para 1, 2, and 3. In here, 4 and 5 only. I don't know.
Then even the contents,
I don't know. Lordship. I have presumed that the same copy has been such.
Mr. Veto.
This matter can come up tomorrow.
No, let's see. Let us see. If the mistake is not very material, let us see. Yes. Just read para 4.
Lordship,
Do you have a statement which starts with the petitioner was allowed to continue in para 4?
Lordship.
Do you have that statement?
Which line, Lordship?
If actually you are both having the same affidavit, then
Yes.
I am actually like the second line in the court's copy, paragraph 4 is the petitioner was allowed to continue even after the expiry of the extension order. Whether that word is there?
Lordship, the petitioner were allowed to.
No, Lordship, the wordings are everything different. In my copy, it's in page 5. Page 3, where it says this begins the state hearing that even after the expiry of the extension order 1398, the petitioner was allowed to continue the service.
See, this is what actually what we say very casual of the government. See, you kindly compare your this thing. Para 4.
Where is your copy? We don't.
That means
Yes, we have the same, apparently we have the same copy.
you have the same copy.
Mm.
Okay. The petitioner, you just read from this. Mr. Veto, the petitioner was allowed to continue, correct?
Lordship.
You read from
That
this?
Same word is not mentioned, Lordship.
The petition, just let us see if you have a,
Lordship, Lordship, I have the petition, if I'm allowed to read, Lordship.
para four,
Para four, Lordship.
your affidavit.
Lordship,
That
with regard to the statement made in paragraph this is a some copy.
Same as committee in here. But the different one was filed before the floor.
second copy, second copy. Whether second copy is the same copy you are having?
Lordship. Lordship, this is a second copy which I'm having. Lordship.
And is it exactly?
Like ours, like.
This is. What to do? This
I'm allowed to make a correction and then
second copy, can we take the second copy?
second.
Okay, before removing this, let us read the second copy.
Lordship.
Yes.
Lordship.
This is, just wait. Mr. B. Jamomi, your first copy, the statements in your first copy and the second copy
Lordship.
is totally different.
Lordship.
How do you make this kind of a affidavit? Read, let us see the second copy.
Lordship. That with regard to the statement made in paragraph 3, 4, and 5 of the writ petition, not correct and denied in total. The petitioner was initially appointed as constable driver under the establishment of DF Kohima on contract basis and was enlisted appointed on.
Okay, so we take this. This is completely different. You keep it in file too, okay? The rest you just, okay. You're reading paragraph 4, 5, and 6.
My lord.
Correct?
My lord, my lord.
Okay, let us, okay, now,
Page 2, paragraph.
yes,
That with regard to the statement made in paragraph 3, 4, and 5 of the writ petition, not correct and denied in total. The petitioner was initially appointed as constable driver under the establishment of DEF Kohima on contract basis and was enlisted appointed on 1/4/1988, which is an annexure 1 of the writ petition. And after the expiry of the initial appointment, further extension was granted to the petitioner, annexure 2 of the writ petition. It is pretended to state herein that even after the expiry of the extension order dated 30/3/1990, the petitioner was allowed to continue to serve in the department. It is also denied that the petitioner remained employed for a period of 3 months from July to September 1990 and not paid any salaries. It is evident and crystal clear from the record that is the pay slip that the petitioner was given his salary for the month of September 1990. The record pertaining to the month of July and August 1990 was not traceable. However, if the petitioner was paid salary for the month of 1990, he must have been received salary for the month of July and August 1990, though the records are not traceable for the month of July and August 1990. The action of the petitioner is therefore misleading and amount to approaching this honorable court without clean hands and the heart, and for which the instant writ petition is liable to be dismissed. Lordship may kindly come to the annexure A of my affidavit in opposition, which is at page 8, annexure A. And the same type copy is at page 9.
This is what you say is payslip.
Payslip, Lordship. This is a payslip, Lordship. Now, the names of the others has also been recorded, but we are only confined to 587. Lordship.
Lazman Sunar. Lakshman.
Lakshman Sunak. Lakshman Sunak. And at last column. If Lordship may
Last
kindly
column.
Come to the last column.
Last column page.
Same page.
Page 9.
Page 9, last column.
Ah.
The amount is
Oh,
1,400.
last column. Amount 1,412.
1,412. This is the for the month of September. Lordship, we could not trace out for the month of July and August, Lordship. But if for the month of September is paid to the petitioner, then definitely the petitioner might have got the salary for the month of
That
July
is the
and
other way
August.
around. The petitioner is saying, even if assuming that September is paid, what is the record for the month of July, August? That is what the petitioner is also questioning. Even assuming.
Lordship, but Lordship, if for the month of September is paid to the petitioner, Lordship, then the petitioner might have got for a salary for, though that is not part of the record, Lordship. And in our
You
statement
may
of-
not have paid him since he was out of service. You may not have paid him from July, August, and thereafter you have actually since you had the mind to let him resume service, you had paid him September. That can also be another way of taking this.
Lordship, even otherwise, Lordship may kindly come to the page 10, Lordship.
Page 10.
This is the revised final seniority list of ASI, MT, and
Yes,
Havaldars
yes.
as on 31st 2016.
Page, which page?
10,
Page, no,
Lordship.
just wait. Mr. Ved, the page 8 is your pay slip.
Payslip
Page 8,
is the payslip.
pay slip. And page 10,
Page 10,
correct?
Lordship.
Page 10 is the
Revised
Final.
final seniority list of ASI, MT, and Havaldar MT as on 31st 2016.
final seniority list.
Lordship.
Okay, let us go to the petitioner. Where is the name of the petitioner?
Is at serial number 13. Lordship.
Serial number
13.
13.
One.
Final revised list of ASI and Havaldar. He was Havaldar,
He was Havaldar and promoted to SI.
list of ASI.
Now,
So in this seniority list,
at the sixth column, Lordship.
he was serving as Havaldar and promoted to ASI. ASI.
Promoted to SI, sub-inspector.
So this seniority list was issued when he was ASI.
No, my lord, this seniority list was issued. Yes, my lord, yes, my lord. At the time when he was promoted,
So this seniority list was issued when the petitioner was in the rank of ASI.
ASI,
Okay.
ASI.
Uh, And what do you want to submit on this?
Lordship, kindly come to column 6, Lordship.
Column?
Column 6.
Column
1, 2, 3, 4, 5, 6.
1, 2, 3, 4, 5, 6. Yes.
At the top, it says date of appointment.
Ah,
So date of appointment is 4/1/1988. Lordship.
he was promoted to ASI on 12/2/2003.
He was
Date of
promoted
promotion?
to ASI on 8/10/2012.
8/10.
2012.
No, then what is this date of promotion? I am finding it quite difficult to understand this. He was, oh, date of promotion, he was promoted on 12/2/2003. What is this 12/2/2003?
That's the date of my promotion to Havildar.
Date of his promotion to Havildar. This is. This is a date of promotion to the post of Havildar Lordship. However, this revised final seniority list was out only on 31st/12/2016 Lordship, when the petitioner was promoted to ASI.
No, this shows that you were promoted, the petition was in the rank of Havildar, correct?
Lordship.
Second December 2003, wrongly shown.
Date of
You were promoted when?
On 2nd December 2003.
there is a typo error.
Okay.
It should be 2/12/2003.
Even my initial appointment is also 4/1.
Zero, it should be 1/4. There is a typo mistake, Lordship. However, Lordship, what I'm trying to say, my Lord, what I'm trying to impress, my Lord, is the petitioner never challenged the revised seniority list, Lordship, which was as on 31st/12/2016, Lordship. And because from the initial appointment, Lordship, he was promoted from the constable driver to the Havildar to ASI, and in the year 2017, Lordship, he was promoted to inspector, Lordship. Basing on this appointment order, Lordship.
Basing on the seniority.
Basing on this seniority as well as the initial appointment.
Where have you stated that statement? Have you made any amendments?
Lordship.
Where have you made that amendment? Let us see.
Lordship may kindly come to page 3. Page 3, paragraph 6, Lordship.
Page 3, paragraph, okay.
If I'm allowed to.
Yes, please.
Paragraph 6, that with regard to the statement made in paragraph 10, 11, and 12 of the writ petition, the petitioner's service was proposed for regularization with effect from 2/12/1998, which is on record, but his service was regularized from the date of joining in service, that is on date of joining, very important, date of joining is on 1/4/1988. The said regularization was accepted by the petitioner without any complaint, and the petitioner have enjoyed all service benefits such as seniority, promotion, etc., counting his service with effect from 01/04/1988. Even in the revised seniority list of ASI, MT, and Havildar, MT, as on 31st/12/2016, the date of appointment of the petitioner is shown as 04/01/1988, which the petitioner have never opposed, but rather enjoy all the service benefits based on his seniority position as 01/04/1988. For determination of seniority and promotion, the petitioner have gladly accepted his date of appointment as 01/04/1988, when it was his benefit, and after availing all opportunities, counting his seniority with effect from so and so, when it has come to determination of 35 years length of service for retirement for public service, the petitioner wants to take another date which cannot be accepted as a claim of the petitioner is unreasonable and illogical. It is pertinent to mention herein that the issue involved in the present writ petition is regarding the date of determination of 35 years length of service for retirement from public employment and regularization of the petitioner,
will have no relevance as it is an admitted fact that the petitioner was initially appointed on contract basis on 01/04/1988 and subsequently regularized on 10/6/2002 with effect from 01/04/1988, which the learned counsel for the petitioner was pointing out, Lordship, which is
No,
which has been
Mr.
annexed in the page 40.
Was initially appointed on contract basis on 1 and subsequently regularized on 10/6/2002 with effect from 1/4/1988.
Lordship.
Is it like that?
Lordship may kindly come to page 40 of the writ petition.
Page?
Page 40 of the writ petition. Annexure 10, Lordship.
Page 40.
Page 40.
Just wait.
Which the
Just wait,
petitioner is banking on this, Lordship.
Yes, please.
Lordship. Here, the petitioner is saying that contract service, if I'm allowed to read, contract service in respect of Constable Driver Lakshman Sonar attached bulletproof car of His Excellency the Governor of Nagaland is hereby regularized from the date of joining, Lordship.
From the date
From
of,
the date of joining, Lordship.
no, there is some word has been erased
Lordship.
to put that word from the date of joining.
But this is the documents of the petitioner, Lordship.
Lordship, this
And-
is from the extract of the service book. Lordship.
Extract-
It's not
extract
my-
from the
It
ser-
was never in my custody.
And Lordship may kindly come to page 34. and the
34
type
of?
34 of the writ petition, Lordship. 34, but
Okay, just,
type
just,
copy is that
just wait. Yes,
type copy is at page 36. Page 36, Lordship. This was communicated by Deputy Inspector General of Police to the Home Commissioner, Lordship, by letter dated 2nd November 1999.
yes,
Lordship, if I'm allowed to read, Lordship.
yes, please.
To the Home Commissioner, Police General Branch, Nagaland, Kohima, subject. Regularization of contract service in respect of Constable Driver Lakshman Sonar attached to bulletproof car of His Excellency the Governor of Nagaland. Sir, I have the honor to state that Sri Lakshman Sonar has joined this department on, here it has been mentioned that initial appointment 1/4/88, Lordship.
This is correct. This is correct. One
This
for
is correct, Lordship. In rank of constable driver on contract basis, initially for 1 year, and his contract terms have been extended time to time. The individual had undergone training in bulletproof car and attached to His Excellency the Governor of Nagaland for driving his bulletproof car, and his performance is found quite satisfactory. By taking into account of his dedicated service with His Excellency the Governor of Nagaland, he was deputed to undergo basic training at PTS Jumukdima on 15/5/1998. He has successfully undergone the basic training and reported back to his assigned duties with His Excellency the Governor of Nagaland on 9/12/98. In this connection, the following documents are forwarded here with so and so 1 to last. Since Sri Lakshman Sona Constable Driver attached with their bulletproof car of Governor Nagaland has successfully completed the training with effect from 9/12/98 FN, it is requested that the necessary order may kindly be issued to regularize his contract service with effect from, here it has been mentioned 9/12 with effect from 9/12/98 from the date of passing out of period of which basic training, Lordship. However, Lordship, from the letter, it appears that he was initially appointed in the year 1988, Lordship. And Lordship, I have also annexed the office memorandum, Lordship, And this office memorandum squarely covers our case, Lordship.
This, your affidavit,
Affidavit in opposition filed by respondent
Yes.
number 1, 2, and 3.
you have annexed many office memorandums, but
Lordship,
all
this
these have
was-
become redundant.
Lordship, this has been superseded,
In
Lordship.
view of office memorandum
Lordship, we
31,
can come to
8, 2017.
31st August
Ah.
2017, Lordship. This squarely covers my case 6, Lordship. 22, which is at page 22, Lordship.
Ha. Yes.
6. Now, therefore, it has been decided that the period of service rendered on ad hoc contract work charge substitute basis, which is followed by regularization or regular appointment without break, Lordship. Here it mentioned that without break, Lordship. Nowhere in the communication letter or nowhere in the revised seniority list that the petitioner was nowhere it has been mentioned that the petitioner was appointed in the year 1990 or whatever, Lordship. But in this revised seniority list also, it has been clearly mentioned date of appointment is of 1/4/1988, Lordship. And from the letter of IGP to the Home Commissioner also, it's clearly mentioned that the appointment was on 1/4/1988, Lordship. There is a consistency, Lordship. And Lordship, this office memorandum covers our case. Why? Because, Lordship, there is no break in service, Lordship. And Lordship, if I may continue, or any gap in service except resignation, Lordship. There is no resignation as such, except there is a statement saying that there is a gap in service, Lordship. And that we have substantiated by placing a payslip, Lordship, saying that no. Yes, we are also admitting to the fact that for the month of July and August, no pay, we could not trace the record. But however, for the month of September 1990, we have paid, Lordship. So we are saying no, there is no break in service, Lordship. And also from the service record, it clearly appears that from the date of his regularization, it should be counted from the date of joining, Lordship.
From the
Rightly or
date of
wrongly,
his-
Lordship?
From the date of his initial.
Initial appointment, Lordship. So initial appointment, they are not disputing, Lordship. Initial appointment, they are also admitting to the fact that I have been appointed in 1988, Lordship. So this office memorandum squarely covers our case where there is no gap in service. Moreover, if at all there is a gap in service, Lordship, if the petitioner say that I have been resigned, and then if there is, but there is no resignation as such. And Lordship, to that, Lordship, I would like to place one of the
Decided by this court.
Lordship.
Yes, let us.
Which, my lord, while you were a senior, my lord was a senior additional AG, Lordship.
Oh, let us see.
My
Let us see.
lord.
But facts may differ.
My lord, this squarely covers our
Facts
case,
may
Lordship.
differ because actually here the petitioner says that there is
The gap.
break in service.
This is 2021 GLR 149. Bingjontoshi and RS versus State of Nagaland and RS.
This is a single bench.
Lordship.
And Mr. Apok, you were also referring to this.
No, Lordship, I was referring to the red appeal, which. is,
Okay,
possible
let us see that also. But yes, Mr.
Lordship.
Yes.
Lordship, with regard to the this is a reference which was taken in the office memorandum 2014, Lordship. WPC 270 of 2011, Lordship.
This is another
Lordship.
Which was the batch of writ petitions.
let us see, let us see.
Lordship, it was we have passed up in 270 in batch of writ petitions.
This is a judgment on order.
Which judgment you are referring? Which judgment you want to refer first, Mr. Beto?
Lordship, I'm referring to 2021 GLR.
2021 jailer, okay.
149.
Paragraphs,
Paragraph 67, Lordship.
paragraph,
Starting from 67, 68.
starting from 67,
Lordship.
paragraph 67.
Lordship. This word.
Just.
Covered my case.
Let us see whether the facts are similar or not. Let us see.
Lordship.
Read.
Paragraph 67. From the above discussion, the following can be observed or inferred. A. Section 3(1) of the Nagaland Retirement from Public Employment Act 1991, as amended from time to time, read to Section 2(1) makes it very clear that 1. A person having completed 35 years of service or having attained the age of 60 years, whichever is earlier, shall be discontinued from service. 2. Such person must have been appointed to any pensionable state public service or post connected with the affairs of the state of Nagaland, etc. 3. As such service should count from the purpose of pension. B. The petitioner were initially appointed on temporary basis as computer grade 2 by orders so and so, and subsequently they were appointed as officer grade 1 by dated so and so. Even though the said post of computer grade 2 and officer grade 1 are different, there was continuity in service. Though the initial appointment as computers was temporary in nature, it was still a government Lordship, very important, it was still a government employment and it was post connected with the affairs of the state of Nagaland. The appointment of the petitioners as computers grade 2 was public employment within the meaning of Section 2(1) of the Act. Though temporary in nature, it cannot be said to be merely engagement on training or apprenticeship as contended by the petitioners. They were subsequently appointed as officers grade 1 while serving as computers grade 2. There was no break in service between these two appointments. It is provided under Rule 13 of the CCS pension rules that officiating or temporary appointment followed by substantive appointment in any service without interruption will count towards qualifying service. The petitioners were appointed on temporary basis as computers grade 2 and were subsequently appointed as officer grade 1 on the substantive basis without any interruption. Here, very important, without any interruption. Hence, their services in the post of computer can be counted for the purpose of pension. Section 2(1) of the Act makes it very clear that if such an employment counts towards for the purpose of pension, it will come within the meaning of the public employment and accordingly will come within the purview of Section 31(3)(1) of the Act. In view of the above, this court is of the opinion that the service conditions of the petitioners fulfill the requirement of Section 2(1) and Section 3(1) of the Nagaland Retirement from Public Employment Act 1991. In that view of the matter, the impugn order dated so and so cannot be considered to be violative of the Act, and as such, there is no merit in the writ petition. Before we part, this court would like to deal with certain other issues raised by the petitioner. It has been alleged that the aforesaid impugn order so and so was issued in violation of the principles of natural justice by not giving any prior notice before such order was passed, and further, it was passed by giving retrospective effect which are not permissible in law. As regards the issue of violation of principle of natural justice, it is also equally well settled that the principles of natural justice cannot be put in a straitjacket formula, and their applications depends on facts and circumstances of each case, and violation of this will not ipso facto lead to a nullification of any such order. In HP Transport versus KC.
No, this are not relevant. This is to do with.
Lordship may.
No, but I don't see anything which has been discussed with regard to the gap.
Lordship, the last paragraph 73, 73 and 74, Lordship. As regard to the allegation of the petitioners that the official respondent act with mala fide while issuing the aforesaid release order, and that it was done to facilitate junior officers to officiate in a higher post, the same cannot be accepted for the reason that no such materials are forthcoming in the reports. Further, merely because some junior officers get benefit.
No, Mr. Veto, those facts are not relevant to the case in hand.
Lordship, here, what I'm saying, Lordship, there is no break in service, Lordship. And
what is the fact which was decided in this case? What is the fact?
Lordship, here.
Not just that, actually, the court has observed that there is no gap.
Lordship.
You cannot just rely on that sentence. What is the fact in this case?
Lordship,
you cannot read just one sentence which is favorable to you. And the judgments of the court are not read in that manner. What about this? What about the other? No, this is not relevant. This is 2020. This is not relevant because we have not gone through the facts.
Lordship, here is a case where there is a continuity in service, Lordship. There is no break in service, Lordship. Initially, the petitioner was appointed as temporary basis as computer graduate. Lordship.
Mr. B. Jimomi, you are submitting certain citations. You want to submit, you want to support your case with that citation. And you have not gone through the citation. You have just read 1-2 lines. There is no break. There is no break. There is no break. You have only gone through that. You have underlined that. But there was no break in service in that context. You have to support with facts.
This was also covered by WPC number 270 of 2011, Lordship, which I have already submitted by law.
Let us see. Let us see.
Lordship.
This is not very relevant, though.
This is the bunch of the writ petition, Lordship.
Yes.
Which were.
Yes, which is that? Which is relevant to you here?
Lordship.
Have you gone through the judgment?
Lordship.
Have you gone through?
Lordship.
What is the fact? What was the fact in WPC 270 and the other analogous cases?
Lordship, here is a case where the bunch of the writ petitioner, Lordship, they were initially appointed as on contract basis, Lordship, and thereafter, Lordship, they after serving for a certain period of time, Lordship, they appear before through NPC, Lordship, and Lordship, here in this bunch of cases, Lordship, where the petitioner was aggrieved that they were prematurely retired, Lordship, from the as per the retirement.
Okay, let us see the observation made by this court in this batch of cases. Which are the relevant observation?
Lordship, we kindly come to page 40, Lordship. Page 40.
Page 40.
Paragraph 30. 34, Lordship.
Page 40.
Page-
Page 40, yes.
Paragraph 34, Lordship. If I may not.
Paragraph.
34.
Huh.
The decision in Jagdish Narayan Supra was rendered in the context of promotion, and therefore the observation of the apex court that a period of ad hoc service is to be excluded while recording the required length of service has to be understood in the context in which the said observation was made, Lordship. The decision of the apex court in Jigwan Ram and ORS brought that the ad hoc appointees cannot claim parity with regular employees in the matter of pay fixation, grant of higher scale, etc. And that such service cannot be clubbed with regular service for purpose of grant of revised pay scale, fixation of seniority, etc. cannot form the basis of argument. That such service necessarily has to be excluded in calculation of length of service for all purposes. An ad hoc appointee may not be entitled to all benefit to which a regular employee may be entitled to, but such a distinction will not distract his position as a government servant inasmuch he continues to be a government servant, Lordship. Why I'm pointing out this principle, Lordship, is that
You go through this judgment. At 2, you address this court, especially on the facts. Especially on the facts. What is the fact and why the facts, and then what observation the court has given, and then how it is relevant to your case. Just to judgment. See, when you actually when you rely on a decision, you have to be thorough with the facts, and you have to actually satisfy that the decision of the court was in the facts and circumstances of that case. You are 2, you come prepared. You go through this judgment and then you give me the facts and then you let us see what will happen. Mr. Abok, you also have this judgment, no? You have one judgment, no? Let us see.
This is reported, Lordship. In fact, 270 is in GLG.
2012. So this 2020.
No, I'm referring to the 270 that my friend was just referring. It is in 2012. Volume 4. It's already reported by Justice A.K. Goswami. And of course, against this, there was a bill which was dismissed by His Lordship CG, Chief Justice A.K. Goyal and Ujjal Bhayan. And against that, Lordship, for the information of all, although there is no stay, nothing, 3 of the writ appellants, they are before the Supreme Court in the matter is still pending, unfortunately.
What about what is that? What is this judgment which is referred in the office memorandum issued by the government?
Lordship, all these are referred, starting from 278 and
what is this? What is this landmark judgment 14 in WA 5K 2017?
Lordship, that is.
What is this?
Sashikalas, if your Lordship can remember. Sashikalas case.
You have that thing?
Lordship, we have.
You have?
It's there, Lordship.
Sashikala.
Lordship,
You have
it's
the
there.
copy?
Lordship.
This 3 judgment, you just go and you just address this court.
Lordship.
Let us resume at 2.
Lordship. All right.
Okay.
Lordship.
So you kindly go through, address this court.
This board of us is relying on this. To say,
The only difference is the gist of the judgment in 78 and the rate of review in all these cases, to my understanding, the judgment is 100% correct. The rate of review is 100% correct. The judgment is 100% correct. The rate of review is 100% correct. The judgment is 100% correct. The rate of review is 100% correct. The judgment is 100% correct. The rate of review is 100% correct. The judgment is 100% correct. The rate of review is 100% correct. The judgment is 100% correct. The rate of review is 100% correct. The judgment is 100% correct. The rate of review is 100% correct. The judgment is 100% correct. The rate of review is 100% correct. The judgment is 100% correct. The rate of review is 100% correct. The judgment is 100% correct. The rate of review is 100% correct. The judgment 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 is No, this case is clear. Tadi kita sih, juga jadi dua ya. Juga jadi. Dua tadi juga sih.
Yes.
Yes, please.
Mr. Veto.
Lordship.
Just,
Lordship, the bunch of writ petition.
just wait. The bunch of 270.
Lordship.
270 and analogous.
Analogous, Lordship.
Uh,
The
what's
bunch
the-
of writ petition which has also been mentioned in the writ appeal 5 of 2017, Lordship. Here, Lordship, here the state prefer an appeal, Lordship, against the single judge order, Lordship. Lordship, in which my lord has appeared, my lord has appeared
In
for the
this
Lordship.
batch of cases?
Not in this bunch of cases, in writ appeal 5 of 2017, Lordship.
No, what about this 270?
Lordship, 270 reference has been made in this writ appeal 5 of 2017, Lordship. This bunch of case, Lordship. So,
270.
Lordship, so I will only refer to writ appeal which the learned counsel for the petitioner is also relying, Lordship. There's,
So
there-
where's the judgment?
Writ appeal 5 of 2000.
Where is the judgment?
It's there, Lordship. I have already.
No, writ appeal
5 of 2000.
Writ appeal is not here. You are relying on this government,
Lordship.
this
Sashikala, the state of Nagaland versus Sashikala.
Yes.
Lordship, here is a case where the respondent petitioner, who was initially appointed an ad hoc as a primary teacher, Lordship, in the GPS Mokokchung, Lordship. And thereafter, Lordship, one post which was lying vacant, that due to the study leave of one, namely one Mrs. K.C. Longan. So, Lordship, she applied for the said vacant post. And thereafter, the respondent petitioner, after she joined for the substitute lecture as a grade 1 Lordship. She was released from the service that was initially she was appointed on the primary teacher. She was released from there, which was issued by the DIS. And thereafter, Lordship, she joined as a substitute lecturer as a grade 1 Lordship. Thereafter, Lordship, a vacancy arose through NPC. And then she was informed to appear for the interview. And there she appeared. And so the NPC, she was appointed in the year 1980. So, her service as a lecturer in the Nagaland College of Education, Lordship, that was regularized with retrospective from 4/4/1988 to 31/10/1988 by a notification dated 1989, Lordship. There, what happened, my lord, in that case, a show cause was issued. A show cause was issued by the applicant, Lordship. And thereafter, she was retired from service for attending the age of 35 years of service, Lordship, under the Nagaland Retirement Public Employment Second Amendment Act 2009. Lordship, on the basis that the service that initially she was appointed in the year 1977 to 1986 was counted. So there was no break in service. In that case, Lordship. So, Lordship, what happened? She also replied to the show cause notice. Show cause notice, and then in the show cause notice, it was mentioned with regard to the office memorandum, Office Memorandum 118/2012, issued by the PNR Department. Lordship, since I mean agree by that, Lordship, since this is a short judgment, Lordship, if I may allow to read the whole judgment so that. So 15-page judgment, Lordship. Read appeal 5 of.
Read from para 8. Let us see the findings, para 8.
Para 8.
Read from para 8.
We have considered the submission forwarded by the learned counsel for the parties. Before going into the merit of the writ appeal, we consider it appropriate that we should reconsider the judgment and order dated 14/6/2012 passed in WPC number 270K of.
This is 270K, is this?
Lordship, a bunch of 270K of 2011 and a batch of other writ petitions as well as the order dated 27/2012 passed by the division bench in writ appeal number 177/2012 along with a batch of other writ appeals. A consideration of the judgment and order dated 14/6/2012 will clearly indicate that after considering the definition of public employment as defined under section 2(1) of the Act of 2009, the learned single judge had come to a finding that an appointment to a pensionable state public service or post connected with the affairs of the state of Nagaland and the Nagaland Legislative Assembly is included in the definition of public employment, and it does not refer to any regular appointment or ad hoc appointment. It was also held that an ad hoc appointee may not be entitled to all benefits to which a regular employee may be entitled to, but such a distinction will not distract his position as a government servant inasmuch as he continues to be in government service. It was therefore opined that in view of the express provision defining public employment, which does not distinguish between regular appointment and ad hoc contract work charge appointment for the purpose of retirement, period rendered on such basis has to be computed for the purpose of computation of 35 years of public employment. It was also held that even if the government had taken the date of regular appointment as a date of joining, the same has to be construed to be for governing service conditions of the petitioner other than for the purpose of retirement. In terms of the finding, those batches of writ petitions were dismissed. When the petitioners in those batches of writ petitions appealed before the division bench of this court, the judgment and order of the learned single judge was upheld by an order dated 27/2012. It is also important to note that amongst the batch of writ petitions, there was one particular writ petition being WPC number 18K of 2012. Therein, the petitioner was appointed as Assistant Plant Protection Officer on ad hoc basis by an order dated 22/11. It should be read as 1976. Subsequently, on the recommendation of the NPSC, the petitioner was appointed as lecturer by an order dated 17/2/1978. In the said writ petition, the petitioner had prayed for a direction to count the period of 35 years from 17/2/1978, the date of which he was regularly appointed. The said writ petition was also dismissed along with the batches of other writ petition by the same judgment and order dated 14/6/2012. After considering the judgment and order dated 14/6/2012 and the order dated 27/2012 passed by the learned single judge, as well as the division bench of this court, respectively, we are of the considered opinion that there has been no mention of or consideration that computing of 35 years length of service in terms of the Act of 2009 should be only with effect from the date of regularization or regular appointment in the same post without break or gap. The next point of consideration is whether the office memorandum dated 1/8/2012 issued by the Department of Personal and Administrative Reform, Administrative Branch Reform, Government of Nagaland has been issued in terms of the judgment and order dated 14/6/2012 and the order dated 27/2012. The office memorandum dated 01/08/2012 is reproduced here below. Subject: counting of contract ad hoc service for retirement purposes. 1. The Nagaland
Okay,
retirement
leave that.
laws.
Come to the observation again.
Laws. Page 12. Laws. Paragraph 12. A consideration of the office memorandum dated 1/8/2012 will clearly indicate that the same is not in consonant with the judicial pronouncement of this court judgment and order dated 14/6/2012 and the order dated 27/2012. There is no mention in the judgment and order dated 14/6/2012 as well as that of the order dated 27/2012 passed by the division bench of this court, indicating that a period of service rendered on ad hoc contract work charge, which are followed by regularization or regular appointment in the same post without break or gap in service, shall be counted as public employment and included in computing the length of service for the purpose of pension under the Act of 2009. Therefore, we find that the office memorandum dated 1/8/2012 is not in terms with the judicial pronouncement of this court. Once the court gives its decision, such decision will be final and binding upon the executive and the government. The executive cannot review or revise the decision of the court, as the same will amount to interference with the exercise of judicial functionings. The executive has to obey judicial orders, having come to the finding that the memorandum dated 1/8/2012 is not in consonant with the judicial pronouncement of this court. The office memorandum dated 1/8/2012 is of no consequences, and we declare the same to be nullity in law. 13. The judgment and order dated 18/1/2016 passed in WPC number 26K of 2015, which has been relied upon by the learned senior counsel appearing for the respondent with petition, has also been considered by us. The fact and circumstances in the said case is different from the case in hand, in as much as the petitioner therein was appointed on regular basis as graduate teacher by an order dated 22/3/1980. Thereafter, he was terminated by an order dated 27/5/1983. The petitioner therein was again appointed as UDA in the Directorate of Treasuries and Accounts Monitoring Cell on contingency temporary basis on a fixed pay of ₹600 by an order dated 18/4/1985. Therefore, considering the factual matrix of the said case, the same is different from the present in hand, and therefore the judgment dated 18/1/2016 passed in WPC 26K of 2015 does not help the respondent petitioner. 14. Coming to the case in hand, it is an admitted position that the respondent with petitioner was appointed on ad hoc basis as primary teacher in the primary school in Mokokchung town by an order dated 2/12/1977, and while functioning as such, she applied against the vacant post of lecturer under the Nagaland College of School Education, Kohima, on substitute basis, which arose due to the study leave granted to one MS Gracia Lungalang upon up to 03/03/1988. It is important to note that she was appointed on 30/4/1986 for a fixed period up to 03/04/1988. Thereafter, during her tenure as substitute lecturer in the Nagaland College of Education, Kohima, a permanent post of lecturer fell vacant. The petitioner applied for the same and was declared successful, and accordingly, by an order dated 31/10/1988, she was appointed to the regular post of lecturer in the Education Department. Further, the gap of the period of respondent with petitioners service on substitute basis in the Nagaland College of Education and the intervening period from 04/04/1988 to 31/10/1989 was regularized by the Department of Education by notification dated 13/2/1989, which was accepted by the respondent writ petitioner. This will clearly indicate that from the date of her appointment as ad hoc teacher by an order dated 27/8/2012 up to the date of her appointment to the regular post of lecturer in the Education Department by an order dated 31/10/1988, there is continuity in service. 15. The learned single judge, while passing the judgment and order dated 18/5/2016, had relied only on the office memorandum dated 01/08/2012 and has come to a conclusion that a respondent writ petitioner has not been regularized as primary teacher, nor was she regularly appointed to the post of primary teacher, and on that account, the writ petition was allowed. As already held by us, that the office memorandum dated 1/8/2012 is not in consonance with the judicial pronouncement of this court. Therefore, the judgment and order dated 18/5/2016 passed by the learned single judge on the basis of the office memorandum dated 1/8/2012 requires interference, and the same is accordingly set aside and quashed. The notification dated 27/8/2012 releasing the respondent/writ petitioner from service on completion of 35 years of service with effect from 31/12/2012 and the consequent release order dated 18/9/2013 is brought back to force. Writ appeal is accordingly allowed.
So it is on this basis that the last notification was issued. But facts are all different. Facts are all different. Anyhow, yes. So,
Lordship. So our contention is that, Lordship, there is continuity in service. There is no gap in service, Lordship. And if you go by the payslip of 1990, which clearly appears that the payment, the salary has been given to the petitioner, Lordship. And moreover, Lordship, the seniority as of 31st/2016, that was never.
Seniority was 31st.
31st. 31st/12/2016.
Then regularization was 1998.
1988.
1998. Regularization.
Regularization.
88 was the date of initial appointment.
Regularized was on 1988. Therefore, the staff.
Initial appointment 1988, regularization effective from 1998, and the seniority lease is 2016.
2016. At the time when the petitioner was appointed was promoted to the post of ASI.
Is it like that, Mr. Abu? Seniority lease was when the petitioner was in the post, serving in the post of Havaldar.
The seniority list as next page 10 of the counter affidavit, Lordship. This is dated on 31/12/2016. By then, Lordship, I was Havildar only.
You were Havildar?
Yes, because my next promotion came as ABI. No, Lordship, 2003, I was promoted as a Havildar. In
Havildar.
2012, I was promoted as
ABSI.
MTS SI.
Huh.
Sub-inspector.
2003, you were Havildar.
Promoted as Havildar.
2008,
2012, by an order dated 8/10.
you were appointed as ABSI.
Lordship, MTSI. That is.
MTSI.
Yes, that is Motor Transport Sub-inspector.
Motor Transport Sub-Inspector. And you were appointed as ABSI when?
13/11/2017.
Okay.
Lordship.
Yes,
my
yes.
learned friend has.
Yes, Mr. Veto, any more submission? Okay, okay.
Lordship, in the first place, I want to come back to the annexure 10. No, annexure B, page 10 of the counter. Lordship.
Annexure?
This, my learned friend has.
Annexure?
Annexure B, page 10.
Of
the counter affidavit.
Yes, annexure.
This is the revised.
Annexure revised final seniority list.
Lordship, in this regard.
Just wait,
This-
just wait. Just wait. This was, this was issued on?
Lordship, this was published. It was never issued, Lordship.
This was published on?
This is.
What is the date?
I think this is 11/11.
Mr. Veto, what is this date? Deputy Inspector General of Police, 11/11.
Last we have the notification, seniority list.
Can you see page 13? What is the date? Have you stated in your petition?
No, to that extent.
Arif? This, what is this date?
Apparently, this is 11/11 or 15/11 something.
It
But-
looks like 15.
Yes. Top, there is a mark. But this is the revised seniority list as on 31/12. So 11 is doubtful Lordship. It can be in the month of November when the date shown at the top of the seniority list is supposed to be on 31/12/2016.
So it should be after 31/12.
That's what I'm saying, Lordship. In any case, Lordship, this was published, but it was never circulated. Lordship, at the backside, after the initial of the DIGP, there is not a single endorsement. Normally, Lordship, we all know when a seniority list is published, it is endorsed to person concerned. Prior to this, it's not the case of the.
You're saying that this is published but never circulated?
Never circulated. When we never got the chance to represent our Lordship, because this is supposed to be the final seniority. The state government has not come forward with the tentative seniority list, calling for objections. We normally do that in the state government offices. But that exercise was not done. Nobody got the chance to agitate. Lordship, there are so many diving errors. My date of initial appointment on contract is shown as 4/1/1988.
It should be 1488.
Yes. And the other one is also wrongly shown. Lordship, that's why we never got the petitioners as well as the others. Nobody got a chance to agitate against this list. It was never endorsed to any individuals, nor was it widely circulated. So this court should not rely on this worship. And that the allegation that I have not protested, when I did not get a chance, Lordship, how can I protest against this? The allegation that I've accepted my date all along, that cannot be under the facts and circumstances. And Lordship,
Yes.
my regularization was done on the strength of the approval letter that I've already shown, but that was approved, Lordship. Page 38
of
my petition.
Thirty-eight,
Lordship.
the type copy is at 39.
Yes, Lord.
And there is
So, Lordship, this is very clear.
For
A specific time and date was given for my
for
regularization.
regularization of the service of the with effect from 9/12/98.
Yes, this has the approval of the PNR department, Lordship. And contrary to this approval letter, entry was wrongly entered in my service.
But this is only for your regularization.
Yes, that's what I'm saying.
That's why this is not very material for your case, because actually what is material is that there was a gap.
Yes, Lordship.
That is why. If there is no gap, we count your service with effect from the date of your initial appointment.
Lordship.
If there is no gap, we count your service from this date.
So, Lordship, my whole premises in which my case is built is that there was 3 months of gap in 1990.
That is
After-
the, yes, that has to be examined. That is the only issue.
Yes, Lordship, it is not the case that I've been paid the salary. They are not saying that. They have washed their hands on that. They have shown a document which is allegedly a pay slip of September, for the month of September 1990, which is also doubtful. Because, Lordship, it is clear as the day that there has been some overriding on that. That page 8. Because September 1990 has been
newly written.
Newly, yes, in the recent past, because the handwriting is different and the legibility is also different. Therefore,
Mr. Veto, what was the so difficulty for you to produce all the prior pages of this so that actually, like if you said a pay slip, means at least the first page of the pay slip, we could have examined that.
Lordship, in fact, this is the way back in 1988, Lordship.
1990.
1990.
But if it is 1990, if you can trace one page, why not the others? The issue arises. If you can trace the pay slip of 1990
for the month of September.
For the month of September, what is so difficulty for you to trace the pay slip for the month of July, August? See, such a thing casts doubt on the mind of this court.
Lordship, that we have clearly stated in our letter. That could not be traced.
That's why you have stated that it is not traceable.
But
Why only the pay slip for the month of July, August is not traceable and September is traceable?
Lordship, that is the only report that was found.
Okay, yes, Mr. Apok.
Yes, Lord.
What is your other, I hope you have finished with your submissions.
I want to go back to the judgments referred by my learned friend. Just of it. Lordship, in all those batches of writ petitions starting from 2012, 270 and etc., up to the recent judgment of the 2017 by passed by this honorable court. In all those cases, the word continuity has been used. In my humble submission, the word continues in service or continuity in
But
service.
the facts are also different.
The facts are also different, Lordship. In the case that Sashikala's case, in Red Bill 5 of 2017, the period after substitute lecturer
Was
has been
counted.
condoned. I mean, it has been, the state government, the
Has been
appropriate
regularized.
authority has passed an order on that.
Regularizing that.
Regularized, it has been regularized. So the facts are different,
That's what I'm
completely
saying.
different. Here in my case, there is a gap of 3 months where I was not employed. That's the difference, Lordship. So when there is a gap and break in service, there is no continuity in that 31st August 2017 memorandum.
That's why this court has to examine your case only on that fact. Because actually the cases referred, of course, I have not gone through the judgments thoroughly, but the cases referred by the learned government advocate, I think the facts are different.
Facts are different, Lordship.
Yes, facts
Because,
are different. That's what I
because
said.
in that particular 270, I was one of the petitioners, counsel, in 18.
270.
In 18K of 2012,
Okay, okay.
where the man was appointed.
So you should be able to apprise the court much better.
Lordship, that's why I'm saying, there was continuity in that.
There was continuity.
Yes, unfortunately.
In those batch of cases.
Yes.
Okay.
So, Lordship, although some were appointed to a different post, in that case also, my client was appointed as assistant plant production officer. Then later on, he was selected by the Nagaland Public Service Commission and appointed as lecturer at SASAT.
So there may be selection not made to the same post.
Although made to a different post, the learned court had held
Said that there is
there
continuity.
is continuity.
Yes, yes, yes,
So-
correct, correct.
So,
You actually, your case in that, the facts in that case was that you were appointed to a different post and thereafter you were appointed to a particular post, thereafter regularized in a different post.
freshly appointed.
Freshly appointed in a
through the
different post.
Nagaland Public Service Commission. But even our argument was not accepted, Lordship, because the court found that, say that the service, although on temporary basis,
correct,
there is continuity. Otherwise, the service should be counted. That's what was held in those
In
batches of
2012.
Yes, there's 270 and so many other cases.
Correct.
And that is, even the division bench has upheld the decision of the learned single judge in that case. So, Lordship, not all of them, but 3 of them have decided to go to the apex court.
Well, what is the fate of that appeal? Even
It's
as of
still
date?
pending, yes, still pending.
Thereafter, so much of water has flown.
Indeed, it has. Indeed, it has. Now, of course, it is our negligence in a part way. We have been trying our engaged councils to get the matter disposed.
I think that engaged counsel has also now retired.
Biggie is still, we engage Biggie Goswami.
BD?
Goswami.
PK.
Yeah.
Oh,
He's
he's
still
still very
active.
smart. He's still very active.
Yes. So we have apprised them, but just recently also we have discussed with them to take it up and then whichever way it goes.
Yes,
It has to come to a finality. And that's what we apprised them.
Okay, so
In one case, I would like to refer by the Supreme Court. This is a-
have you given us the copy?
It must be here, Lordship. This is 1995 Supreme Court. AIR 1975.
Yes.
1995. Just. Para 9 is just.
Just wait. Let us see.
Just on the subject of continuity of
Just,
service.
afterwards, you make photocopy, okay? Just note down.
Para
Whatever.
9 is
AIR
1995.
Just wait.
Supreme Court.
AIR 1995. 1995
Supreme
SC
Court.
page
2318.
2318. Para,
Para 9 is the relevant motion.
Para 9.
Where it has been held.
para 9.
Yes, Lordship.
Para 9. Can we see, okay, this, tell the librarian to make photocopy of it, okay? You have noted, good. Yes, para 9, can you read?
If there is an, Lordship, there was only one copy of that.
Of this book?
Yes,
Okay.
in the library. So
But for
then
the
the gist
opposite-
of it is that if there is an interruption between two appointments,
We hold that there being interruption in the present case between the temporary service of the respondent number as pool officer and the subsequent substantive
appointment,
appointment. Being interruption in the present case, the period of temporary appointment cannot be counted as qualifying service for the purpose of, but since there was actually like interruption.
yes, it was an interruption. Or Lordship, interruption and meaning can be probably taken as a break in service.
So you
or
are
gap.
also saying that actually there is interruption
Gap
of 3 months.
Yes.
Okay, well. Yes, please.
Since we are not going into that line, I think I will not submit the other ruling. So, Lordship, in my respectful submission, the 31st August 2017 memorandum, which holds the field at the moment in Nagaland, relation to the subject. My case is squarely covered by that, and in view of the fact that there has been 3 months of gap and there has been interruption, and it was only
That is the only ground which this court has to apply. The mind.
Worship,
Correct.
I hope
Because
your
actually
lordship
like
will be able to
your
take a
case,
pragmatic view on that.
although we have heard at length, your case primarily is that there is actually interruption in service for 3 months.
Yes, there is a break.
1990, June, July, July, August,
July,
September. Yes.
July, August, in September.
Which is being disputed by the government with the payslip.
With
The
regard to the
payslip.
month of September. Lordship.
Ah.
Otherwise, the 2 months, July and August, they have no proof. It is up to them to disprove my allegation, Lordship, and they have not been successful in doing that. So, in my respectful submission, the impugn notification has been wrongly passed.
You are retired.
I've been retired, Lordship.
Oh, you are retired now.
Yes.
Okay, so even if you are instated, you get big wages
Yes,
plus the balance.
Yes,
Period of
up to
service.
28, up to April 28.
Yes, we will consider.
Lordship, we can consider that aspect of the matter. So my respectful submission is that the impugn notification whereby I was released from service, the quashing set aside, and I may be allowed to resume my duty as before.
Yes, call, where is? Please, take this, okay? Take this picture, okay? Mr. Apok Pongner, the learned counsel for the petitioner, and Mr. Bijmomi, the learned government advocate for the state respondents. Heard the parties at length, judgment and other reserve. This you have made photocopy? Okay, you place it, okay? Yes.
For hearing.
Just, this is. Okay. this also, you can just combine together. Yes,
For hearing, item number 13.
yes, what is this?
Lordship, this matter was heard by Lordship on two occasions.
For?
On two occasions, Lordship. On 2/9/2024, Lordship. Lordship heard this matter to some extent. And during the course of hearing, Lordship wanted to know whether the director is the appointing authority for Tubasi officer grade 3, Lordship.
Okay.
And director is the respondent to file an affidavit. Who is the competent authority to appoint the officer grade 3? Lordship may recall this pension matter. The petitioner is the mother of the deceased government employee.
Have you filed the affidavit?
Yes, Lordship.
Okay, we hear it after a week, next week. Yes. Listed again after a week. Okay, we listed after a week. Any date? Next Thursday?
Lordship.
Next Thursday, listed again on.
19.
But it is not a parted matter, huh?
No.
Not a parted, listed again on.
19.
You,
Trustees,
19.
Lordship.
19/9/2024. You are for the
Respondent number
AG.
4.
AG.
Standing on.
Tell Mr. Joshua to be here
Yes,
on
Lord.
19th. We want to dispose this case.
Tuesday.
Nineteen. Okay,
Lordship on 17.
17. Why Mr. Joshua will be out 19?
Yes, he will be out of station on 19.
Only on 19th?
Yes, Lordship. Then make it on 24, Lordship.
Okay. He'll be there on 17th.
Yes, Lordship.
Tell him to be here. This court will pass order.
Yes, Lordship.
Okay.
Yes.
And tell him that the accountant general has already written to the government. And on the basis of the letter written by the government has replied. The accountant general is sitting over that. In this case, I don't know, but I have seen that. So tell him to come prepared,
Okay, Lordship.
because this court wants to pass some direction. Okay?
Okay, Lordship.
Yes. It's again on 17/9/2024. Okay.
God bless you.